Hello and welcome to the program. I'm Shola Sheyeli. Reactions continue to trail the Supreme Court judgment on Executive Order number 10, with many lawyers insisting that the court did the right thing. I spoke to Senior Advocate of Nigeria, Chijioke Okoli, to get his views on these and other issues.
First and foremost, I would say, even without reading the judgment, that I am not surprised in the sense that the executive order left, right, and center by the federal government, especially under Buhari's presidency, it's a relatively new phenomenon, as if the presidency of Nigeria started in 2015. I'm old enough to remember a bit of Shagari presidency. There wasn't much anybody talking about executive order. Even Obasanjo, who temperamentally was a lot more inclined to testing the very limits of presidential powers. But even at that, we did not see recourse to executive orders, which is a way where the presidency could overreach itself. Now, all of a sudden, we discovered lots of usage of executive orders, and more often than not, controversially, stretching the boundaries of the constitutional definition or delimitation of the powers of the presidency and even the powers of the federation vis-a-vis the states. So where in the presidential order that the president will begin to dictate, as it were, to the states in a federation, it's, from point of view of principle, it raises some curiosity. So for me, I'm not surprised.
The way that the judgment
the way the judgment went, speaking about general principles. Yes.
Okay, let me move on to the case of Abba Kyari, the Super Cup, which is also very topical right now. Some lawyers are arguing that it can be extradited. Some others are saying that it cannot. I have heard some lawyers cite Section 3, subsection 11, number 9 of the Nigerian extradition law, which says that extradition application will be rejected where the fugitive criminal has been charged with another offense under Nigerian law, other than the offense for which his surrender is sought abroad. I've heard some people cite this, and the interpretation has been, depending on who you're listening to, interpreted in different ways. Some people think that the move to charge him under Nigerian law with some offenses is just to prevent his extradition because of this section. But I don't know how you're reading this and what the extradition law says.
For me, I am not so much going to be as critical as it is. I'm not going to be too, for us to be detained too much about the fine points of law. For me, the Extradition Act is, I've read it, it's written in plain English. The literal interpretation on the surface that with his present problem, there won't, I won't say definitively because I'm not a judge. It's only a court of law that can speak those pronouncements. But reading it and interpreting it literally, as the court says that we should subject the statute to literal interpretation, it doesn't seem that you could just whisk him off to US when there's a major charge here. Because, let's face it, criminal offenses are wrongs against the state. So, which the state has a right to redress. If he's offended us significantly, and there's also some offense to the US, charity begins at home. It is in the interest, self-interest, jurisprudentially speaking, of the Nigerian state to make sure that offenses against its law, an attack against the foundation of the state, is properly redressed. So to that extent, you can understand the jurisprudential basis where that particular piece of provision of the Extradition Act is that if you have committed an offense here, the state that has custody of you, of the offending person, has, as it were, right of first refusal. It is jurisprudentially prior, it's right, priority. So that. But for me, I move away from those strict legalese and look at the wider issues that it is well and truly shocking that a man who everybody had looked upon as a, not just super cop, it was like an inspector general of Nigeria in waiting. We haven't, let's be clear, he hasn't had his day in court. But so much is already in the public domain that we will be justified in discussing some of those things. Because for me, my point is, like they say, Caesar's wife should be beyond suspicion. You live above board. There are certain things that he shouldn't even allow himself, given his lofty position, for there to be a whiff of suspicion. As a lawyer, there are certain things, it is not criminal, but for me, there are certain things that will say that it is not compatible with my status as a lawyer, much less as a senior advocate of Nigeria. The same way you're talking about people in the priesthood. The same way for public servants, particularly policemen. So what you have in the public domain, even without making a definitive statement, is a source of worry that this is a calamitous collapse of the system. Because what they are talking about, what is already in the public domain, first, his dealings with hush puppy. And I will tell you something, it's not colonial mentality. By the time the law enforcement agencies in whether US or UK starts looking for you, they have it loaded. It's not like what we do here with our people. They will charge somebody to court.
And start looking for the evidence.
Then they go there and it's so ridiculous. They oppose bail and say that why they want to oppose bail is that the person would interfere with investigation. So you haven't finished your investigation, then you quickly rush to court. In US, I've had the privilege of being close to criminal prosecutions in the United States of defending people. They drop the file to you. You do plea bargain in the Ibori case, which is where I'm coming with some of this very cynical attitude of Nigerians. Virtually the same set of facts that Ibori went scot-free in Nigeria, but it got to UK. He changed his plea. And you see, that's what we keep talking about in Nigeria with the law being so unstable. You get one judgment here, you get the other place. In UK and how it should be in Nigeria, a diligent lawyer could tell you with certain level of certainty the prediction of what's going to happen. And that's what happened there. For example, I go to US, I have to advise cases that in Nigeria advise the US lawyers or the clients who have things here, or UK. You always are being very defensive because these people have the same legal training as the common law. They bring up a judgment that they know the facts and they say, how do you justify it? You're talking from two sides of the mouth. So any Nigerian lawyer who's had some sustained interface with lawyers in Britain and UK will tell you. Because they keep throwing things at you, they will tell you, how do you justify this judgment? and you are
You're at a loss for words.
precisely.
You don't know what to say.
Again, so it is of utmost importance that all of us, because what it now happens, a lot of times you go on the social media, the young lads are complaining, oh, no payment, no payment. The truth of the matter is that where you have what I call rule of law deficiency, the practical implication is that the practitioners of law are the first casualty. People would not want to subject their dispute to resolution within such a capricious, broken system that is a Russian roulette that you're doing. So you advise a client you have a fairly good case or whatever, and then the what now comes out is it's a grotesque distortion of what you would have. So a lot of times, instead of saying this is what is going to happen, you're still saying, well, a lot depends on the judge.
There's no certainty.
There's no certainty, and that is the fundamental issue with rule of law.
So, Leonard Silk, what must give? If we're to talk about solutions, reforms, and because you've identified so many problems, and a lot of the lawyers also know these problems, the delay, appointment of judges, you put people who are not fit for purpose in office and say they will learn on the job. Some of these issues that you've brought out. If we're to talk about reforms, and I know that the NBA is at the forefront of driving reforms, there was a Justice Summit that was held in Abuja a few weeks ago, and we had members of the bench, members of the bar, all saying that enough is enough, and we need to push for reforms.
You see, we lack good men in positions. We just take one phrase and run away with it. Oh, build the institutions, not men. Build the institutions, not men. What makes the institution? It's not just the men. With all the over 200, 300 years institutions Americans thought they had built, it took a Donald Trump to virtually crash it down. If it's my thesis, and most informed people believe so. If Donald Trump had won a second term in the United States, by the time he finishes, all those institutions they keep talking about, it will crash down. Even the Republican Party, that is an institution in itself. So we need to get good men in politics and in positions where they will need to stand up. Because the issue of administration of justice is too important to be left for only judges or even lawyers. Because at the end of the day, this interferes with everyday lives. We're asking why Nigeria has become what it is. The youths are getting involved in all sort of ritual. It's because there's an anomaly. Like my good friend and brother, Professor Dinkalu, will say, you can't run any system on the basis of Ejoma Binu. Somebody has committed mayhem. He goes to kneel before there's a guy and start begging. No, the rules are there. You break it, then we follow the rule. So you have rules how you go to appoint people. For starters, what we want is a situation where the Supreme Court, like in the United States, controls its docket. Or what I propose is that each geopolitical zone will get its best. 6. Then the other 3, by whatever criteria we use to define merit, will get it. And within that 3, we will cater, in addition to merit, that we will take cognizance of some significant section of the society that may not have been represented in that 6. 1, if there is no lady, which is quite possible, after that 6. So when we're taking these 3 to make up, we keep that in mind. If for any reason there is no Muslim in this number, and given the importance of Sharia law, then we also take into consideration that among this marriage will be somebody who's well schooled in Islamic Sharia jurisprudence and other things. This will put it there. So, and we will make sure when you have 9, you won't have a tie. And then we would, because if things are not spelled out in Nigeria, we have a way of making straightforward things complicated. If for any reason a judge is incapacitated, that would mean that you're left with 8. Automatically, any case coming up there, my proposal is that the president of the Court of Appeal automatically will sit with those people, because it's basically the same qualification they have. If there are 2 missing, the next ranking judge will sit with them on an ad hoc basis.
Ranking judge
of the Court of Appeal will join the president so that we make sure that each particular point in time, we won't say we are lacking quorum. They can sit there and go back. But we need to free the Supreme Court and make it really well and truly supreme. And for me, if United States, with all its complexities and everything, is making do with 9 justices, I can't see why we cannot prune our own number to 9.